Hi, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're doing verdicts and settlements for shoulder injuries. So if you have any type of shoulder injury or are just curious what these personal injury shoulder cases go for, let's get into it. So the shoulder, and you could see here, has a lot of different components. It gets a little bit complicated. And the common injury that you see a lot is going to be a supraspinatus tendon tear. And if you have a tear of the supraspinatus tendon, it can be repaired by an arthroscopic surgery, which is where they have like a camera, they go in, it's minimally invasive, and they repair it. Sometimes the injury is more involved and it cannot be repaired arthroscopically. And the doctor may have to use an anchor, and those cases are usually worth more. So I would say arthroscopic surgery cases can be worth anywhere from like 100 up to maybe like 300,000-400,000. Whereas if you're using anchors, if it's a more involved surgery, you might go up to even closer to $1 million, like 750, 850. And then if you need something really, really serious, like a permanent injury where you lose mobility in the shoulder, some people even need like a shoulder replacement, something like that serious, that could obviously be well into the millions. But this just shows all of the different parts of the shoulder, such as the infraspinatus tendon, the supraspinatus tendon. Sometimes there are impingement injuries like the AC, they call it the AC joint, that's the acromyoclavicular ligament. There's the scapula, there's the clavicle, and then the bone that it stands on is the humerus bone, which goes from the elbow to the shoulder. But let's get into some of the verdicts. So here's the most recent. I ordered it by most recent, and I included the shoulder injuries nationwide, so we don't limit it only to one particular city. And the most recent one actually comes out of Nassau County, New York, which is Long Island, and it involves a motor vehicle incident. And what happened here, it was decided actually on September 16th, 2024, so just last month. And what happened here was that on September 28th, 2019, the plaintiff, who was 63, he was a bus driver, he was driving on Franklin Avenue in Valley Stream. And what happened was the defendant was pulling a vehicle out of a parked position on the side of the road when it struck the front tire of the plaintiff. So the plaintiff claimed injury to his shoulder, which he attributed to the crash, and he sued the defendant for negligent operation of her vehicle for just pulling out of a parking spot right in front of him, and then he also sued the owner of the vehicle. So what happened was the plaintiff actually declined medical care at the scene, and he began physical therapy several weeks later. And he was diagnosed with a partial thickness supraspinatus tendon tear in his left non-dominant shoulder. And he claimed that the crash caused his shoulder to hit his vehicle's door, and he had 3 months of physical therapy and received 1 injection. He initially stopped treatment in January of 2020. So it happened in September, he stops treatment in January. So he treats October, November, December, 3 months, right? Because it happened end of September, 28th. September has 30 days. So you're talking like just 3 months. So he stops treatment in January. But then in August of 2021, he saw a surgeon and underwent an arthroscopy that same month in August of 2021. And he attended a 1 follow-up appointment in 2023, but had no other treatment. And so the plaintiff said that he had trouble raising his arm above his chest, lifting items heavier than 15 pounds, and he sought recovery of $50,000 to $150,000 in damages for his past pain and suffering. So he gave this range, I don't know what the range is about, 50 to 150. But for his future, he was looking for $95,000 for his future. So that's the plaintiff, right? Now the defense argued that the collision was minor, should not have caused the plaintiff's shoulder to even touch the door, and the defense counsel argued that the plaintiff's injury instead was from occupational wear and tear, noting that the plaintiff previously worked as a laborer years before this crash. And the parties negotiated a high-low agreement. And if you watch other videos, a high-low just means, if the case gets 0, well, the plaintiff still gets the low. And if the case, gets, I don't know, $100 million, well, no, you get the high. It's like an agreement, parameters that the parties can negotiate, and then you go to trial with that high-low in place. So damages could not exceed $25,000, which was the limit of the defendant's insurance coverage. However, damages had to equal or exceed $5,000. Oh, I see. So the defendant only had $25,000 policy. So they went 5 to 25. Basically, if he got 0, he still gets the 5. But if he hits for like 100 or anything over 25, it's just going to be 25 because there's no more anyway, right? That's their policy. So it was a 5 to 25 high-low. The result. The shoulder fell over. The shoulder fell over for this result. The result was the jury returned a defense verdict, 0. They goose-egged the plaintiff. They sent him home with nothing, but he still got $5,000 because of that high-low. The jury decided that the plaintiff did not sustain a significant limitation or use of a body function or system, nor a permanent consequential limitation or use of a body organ or member. So that's basically the law about serious injury. I guess they decided that his injury was not caused by the crash, or maybe that it was just, he had the tear, but maybe they said, hey, this is from working as a construction worker for your whole life, because he was 63, not from this crash. I guess the crash was minor, and that's the jury's decision, unfortunately. The trial information has that the demand was $22,500. The offer was actually $15,000. So they could have taken the 15. The trial took 1 day. The jury deliberated for only 39 minutes. The jury vote was 6-0, and the jury was composed of 2 men, 4 women, with 2 Asians and 4 white people. And this is in Nassau County, Long Island. It's a very conservative venue. It's a tough place to get any real money. Okay, let's go to the next case. The next case is a lawsuit, and it's titled "The Home's Unsafe Stairway Led to a Realtor's Fall." And this was a case out of Connecticut. So let's look at what happened here. A married couple, they sued a property, it's called a property LLC, after the husband fell down an exterior staircase at the defendant's property in Connecticut. And the plaintiff was a realtor. He was showing the property to a prospective buyer at the time, and I guess something was wrong with that exterior staircase. They say he violently fell down the stairs and he doesn't really know what happened. And in May of 2023, the plaintiffs filed this $1 million offer of compromise saying, hey, let's settle this for $1 million. But the defendant never made an offer. They had experts, they had an engineering expert as well as an orthopedic surgery expert. And the defendant was this property LLC, I guess, that owned that particular property. The injury was that he broke his right shoulder, 10 ribs, and had his right tibia and fibula broken. And he had a large bruise on his head. He required surgery that included the insertion of hardware, and he developed a pulmonary embolism with 2 deep vein thromboses that led to additional hospitalization. And he had to inject himself with daily blood thinner, and on one occasion he developed massive internal bleeding that necessitated another hospital stay. So a really bad injury. And at the time of the trial, he walked with a limp and had balance issues, and he said that he could no longer show houses with stairs, and he became an aide to mentally disabled people, so he had to change his career. So he sought recovery of $513,000 in past medical expenses. He also sought non-economic damages, and his wife filed a claim for loss of consortium. The result was the jury determined that the defendant had actual or constructive notice of the defect that caused the fall. And they further concluded that the defect was a substantial factor in causing the fall and the injuries. The jury additionally determined that both the plaintiff and defendant were negligent, with 75% of the liability going against the defendant and only 25% to the plaintiff. The jury awarded the plaintiff $4.9 million. And after the comparative fault reduction, his net award was $3.675 million. And the jury also awarded the wife $250,000 for loss of consortium, bringing the total damages to $3,925,000. And in addition, the offer of compromise earned 8% interest. Remember, because they did that offer that you could settle for $1 million. So they had 8% interest on that, and which he estimated brought the total award up to $4,014,000. So it wasn't an easy case, but they said the jury did the right thing. After the verdict was returned, he says he saw the husband and wife walking away holding hands, and he said he'll always remember that. There was no one around. It was just nice. I felt good that they were going home to their kids to say we won this case. So it was so that's basically the verdict. So yeah, it was a pretty good. It was a 3-day trial, 3-hour deliberations. The defense counsel filed a motion for collateral source reduction and a motion for remittitor and a motion to set aside the verdict and order a new trial. But it was definitely a win. The demand was $1 million. There was no offer. And I want to go back to the facts just to see if there's anything about how this happened that could shed some light as to the liability. At first, the plaintiff, the person that fell, said, "I don't know what caused me to fall." But when he got to the hospital, there was a statement made right to the emergency room that something at the top of the stairs must have tripped me up. And then when they went back to the location to take a photo, they saw that there was some kind of bracket sticking out right near the top of the step that was a tripping hazard. And then they also had an expert, a safety engineer, who said that the handrail was unsafe. It was not the right height. So that was their basis for liability, but it wasn't an easy case. So the fact that they won this $4 million verdict was very, very strong. I think maybe because it was a unified trial, the jurors were a little bit sympathetic towards him because he had these horrible injuries, and they may have, it might have played a little bit of a role, because if you have this kind of case bifurcated, meaning you're only trying liability and they don't know what your injuries are, that liability sounds, haven't seen the entire trial, but it sounds kind of weak. So yeah, but that was a good result. Okay, let's go to the next case. The next case is a case out of Ohio. And what happened here, the title of it is that a rear end collision was alleged to have hampered a coach and the coach's abilities. So it happened out in Hamilton County in Ohio, and it was an automobile case. The verdict came down on August 29th of 2024. The plaintiff was 64 years old. And so what happened was, and by the way, I know the attorney that represented the plaintiff. He's a friend of mine, and I've actually done some CLE classes with him. He's a really good attorney. So he represented the plaintiff, and the defendant, it was State Farm, which a lot of people have heard about State Farm, like a good neighbor. State Farm is there, except when you need them to pay, and they're not there. Like a good neighbor, no one's home. But that's another story. So what happened was, like I said, it was a 64-year-old gentleman. His name was Jack, so let's call him Jack. So on June 21st, 2021, Jack was driving on Main Street in Cincinnati when he was rear-ended by the defendant. So the defendant fled the scene but was later located, and the plaintiff claimed neck and shoulder injuries. Now, Jack sued the defendants, the driver and the owner of the car, and he claimed that they were negligent. And he also sued State Farm for underinsured motorist benefits, UM. And so the defendants settled prior to trial, and liability for the accident was not in dispute because it's a rear end. The injury is that he went to urgent care the day after the accident. 3 weeks later, he saw his general practitioner, who referred him to an orthopedic surgeon. He had whiplash in his neck, a tear of the left dominant shoulder's rotator cuff, along with bicep impingement. He attributed his injuries to the collision. Now, he had physical therapy and received a shoulder injection. He then had shoulder surgery in May of 2022, and the procedure included a rotator cuff repair and a bicep tenodesis with distal clavicle resection. And Jack subsequently followed up with additional physical therapy. So before the crash, Jack was a retired carpenter and electrician who enjoyed doing jobs around his house, as well as an assistant coach for for a local high school football team. And since the collision, he claimed he could no longer perform jobs around the house and had difficulties demonstrating football techniques to the players. And he stated that he specifically had trouble with overhead movements. So Jack sought recovery of damages for his past and future pain and suffering. The defense argued that Jack had pre-existing conditions throughout his body, specifically noting degenerative arthritis in Jack's shoulder. And however, according to plaintiff's counsel, the defense's medical expert conceded that the crash necessitated Jack's shoulder surgery. And so the result was the jury awarded Jack $450,000. So that's like typical, you know, like I think that's more along the average of what I'm seeing, anywhere from like 400, maybe up to like, you know, 850 for these kind of shoulder surgeries, like rotator cuff tears. And so the verdict broke down as $300,000 for future pain and suffering, $150,000 for past pain and suffering, for a total of $450,000. The demand was only $150,000. The offer was actually $105,000. The trial took 3 days. The jury deliberated for 2 hours. The jury vote was 8-0. It was 5 male and 3 female. And yeah, so that was basically the case. So I hope this was helpful. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. Please like and subscribe to our channel. If you need a consultation, just text me 347-566-9595 and let me know your name, the facts, the brief, just 1 or 2 sentence facts of what happened, your injuries, and your city, and I'm happy to schedule a call. Okay, everyone, have a great day. Talk to you soon.